All right, seems like we have some people trickling in here. Just as a reminder, I'm Mike Morgan. I work with Jonathan at TF Labs, and I'm incredibly excited for this next session. This is something that very few people really know about as deep as our next speaker does, and even fewer people are as courageous to jump into an online platform and discuss it. And so we've got a wonderfully talented lawyer based here in Washington State with us today. His name's Joseph Vincent, and we at TF Labs are just a tremendous fan of his thought leadership in the space and what he's doing for us. So Joseph, why don't you go ahead and introduce yourself for everyone?
Sure. I'm Joe Vincent, and I have a regulatory law practice and regulatory consultancy. I'm based in Tacoma. Prior to May 1st of last year, for 18 years, I was the in-house general counsel, that is Director of Regulatory and Legal Affairs for the Washington Department of Financial Institutions. Now, a lot of folks don't know that Washington DFI actually is one of the more progressive states in the area of cryptocurrency regulation and DeFi, to the extent that, yes, we're allowing it, et cetera. And so most of that activity would be regulating cryptocurrency exchanges as money transmitters, et cetera, and then beginning to look at them nascently within DFI's Division of Securities from a standpoint of securities issues. Then there's a whole host of efforts to create crypto asset trust companies for purposes of custody of hot and cold wallets, et cetera, et cetera. And that's done by the Division of Banks. Now the Division of Credit Unions is getting into the act, et cetera. For the last 6 years, I've also been an adjunct professor of law at Seattle University School of Law, where I teach a traditional banking law course that's become less TradFi and more innovative in recent years now that banks are jumping on the bandwagon. And then I also teach in the spring each year a introduction to the law of financial technology, or fintech course, which is heavily involved in taking students through cryptocurrency and stablecoin. And also, for the first time this year, in the spring offering of this course this year, we're also exploring NFTs. I don't admit to being the best of experts on NFTs at this point, as opposed to every other kind of digital asset, which I'm more thoroughly familiar with. But let's just say I'm an active student in this area. And given my other background, I've been really thinking hard on this subject for the last few months. So that's my background. You can find me on LinkedIn, where I actively post. And if you want my contact information, I'll provide it to the organizers at the end.
Fantastic. Well, unbelievable pedigree, and we're just so lucky and thankful to have you sharing some of your extensive knowledge and wisdom with us today. I think an interesting place to start out is earlier in the day we had a conversation about this company called CryptoFunks, where they took the CryptoPunks NFTs, arts, flipped them, sold them, and then they were sent what was effectively a cease and desist order and a copyright infringement. And so they took that order and they turned that into an NFT and sold it. And they did a fantastic job of doing it. But the real question at the center of it is, what does IP look like in this space? What does copyright and protection of NFTs look like? Does it exist, or what are your thoughts on that?
Well, when you're talking about art, you're talking about somebody's original work of art. And so all of these kinds of intellectual property are capable of being copyrighted. They're copyrightable. A little information on copyright. You do not actually have to file something with the United States Copyright Office for you to have a copyright on it. You simply have to put a C in a circle on it. Anybody who has actual knowledge that you're claiming that to be your copyright, actual knowledge is suable if they infringe upon that copyright. Okay, what copyright registration allows you, now I'm talking about traditional law, okay, but traditional law in this area and other intellectual property law applies equally to NFTs. You use copyright registration to afford constructive notice to the whole world, so that you're protected against people who don't have actual knowledge but infringe your copyright. Okay, if you can wrap your arms around that. And that's the whole purpose of a registration system in the area of intellectual property. The same thing holds true for trademark law. Trademark is a big area that we're seeing now. I've been following this NFT fashion world. There was a fascinating article I read in Vogue Business about fashion NFTs, and there are emerging trademark lawsuits associated with wearables, the NFT of wearables. So you always have to consider an NFT, specifically when we're dealing with art and collectibles, or even certain gaming tools like skins or certain things you can buy. Anything that can be defined as a piece of art or having artistic value of some sort as being something that's copyrightable, and the brand on it, because one of the organizer here, Jonathan Blanco, the CEO of NIFMIT and TF Labs, he's big on brand. I know that about Jonathan. He's a friend. He's been a client, and we have to think about brands as such as being very much involved in trademark laws. So all of those considerations have to come into play. So,
understood. Well, it's fascinating. It's absolutely fascinating. So there are protection for people from having my own personal copyrighted, branded, trademark material being NFT'd and sold by other parties.
That's correct. And so you'll want to, when you're going out and you're copywriting something, that you're putting an NFT on, because sometimes really when you're NFTing art, really what you're doing is you're creating a certificate of authenticity for an original work of art that exists outside the NFT itself. Now, there's some NFTs where the artwork itself is within the NFT, okay? But there's some uses of NFTs simply to create a digital certificate of authenticity for an offline work of art, okay? But you want to understand that if you're going to start doing copywriting in this area, if you're going to start so that you can put the whole world on constructive notice and protect yourself, or if you want to protect yourself in the trademark area by putting the whole world on constructive notice, even if they don't have actual notice of the use of brand, that you're claiming this brand for itself, and you want to include discussion in your trademark application, your copyright application. You want to include as the rights, NFT rights associated with those. Now, I am not, that's not my area. I'll confess that I am a banking, fintech, and DeFi attorney. Okay, that's my background. But I know enough about intellectual property and work with intellectual property lawyers to tell you, and I've done a little bit myself, to tell you that these are the broad stroke issues. I think I have a message to bring here today that's more focused on not getting in trouble with securities regulators.
And I would love to move there, because I think while everybody in this session is probably interested in protecting their own intellectual property or not infringing someone else's, I think we're all a lot more concerned with some big 3-letter organizations out there. And so
that's correct.
So why don't you talk to us a little bit about your thoughts on securities in the whole NFT space, and sort of what your opinion is, and what the government's opinion is right now, and your thoughts on that whole ecosystem.
Well, it's based upon some very well settled general principles of securities law. Okay. Now, many of the folks out there are going to know certain things like the Howey test or the Reeves test of what constitutes a security. The Howey test is a case dating back to mid 20th century that's basically involved an investment contract involving Florida orange groves, and it basically set forth a three-pronged test, which included that you're an investor in some kind of investment contract in which you're relying on the efforts of other third parties for the enhancement of the value of your investment, or the value of your investment going up in price. There has to be an expectation of profit element, okay, even if minor. There's some kind of expectation of profit of that investment you made. And the key element here, for purposes of our discussion today, is that there's an expectation or need for third parties, that third parties are going to extend their managerial efforts that will enhance the value of the NFT, rather than just allowing the blind supply and demand of a market. Okay. So the audience out there, if you don't have a background in securities, and I don't know the temperature of the audience out there, but what I would say is, you all know that a security is a tradable financial instrument. It can be either ownership in stock or bonds, or it could be some kind of mutual fund under the Investment Company Act of 1940. It can even be a money market mutual fund. It can be a mortgage-backed security. It can be a lot of things like that. But we typically understand, we know what a security is most of the time. But what if we're talking about NFTs that are art or collectibles? How could we get into a securities issue there? So I'm going to give you the standard law professor's answer, which is, well, depends. Okay.
And we'll cut it off there. Thanks, everyone, for coming. No.
Yeah. But finished products whose value is determined at sale, that is made directly to a buyer, arguably should not be securities at all. And I think that the SEC or the Commodities Futures Trading Commission would, as just a pure statement of that, would probably agree with that statement. Okay. So there's typically no expectation or need for third parties to extend their managerial efforts that will enhance the value of the NFT, because really what you're simply looking at is, you sold someone, you minted an NFT, like Nift Mint minted an NFT as a service for one of its clients, and then that was issued to them, okay, in return for some property. And the value of that going up and down would be entirely determined by the invisible hand that Adam Smith talked about, the supply and demand. That it wouldn't be based upon any efforts of actual human third parties, their managerial efforts. Okay. Which is, so that makes it vastly different from my getting involved in an initial public offering, or at or a few years ago in these initial coin offerings, where people were offering cryptocurrency basically, and they were using the funds to actually build the business. Okay.
Not only that, they were offering returns on investment. They were promising returns.
Right, and we'll get to that in a second. So So what about in the NFT concept? Well, if all you were doing is what I talked about a minute ago, you're minting NFTs, okay, you're selling them to people, and the pure market of supply and demand is responsible for the price, and not the efforts of the managers of the enterprise that created them. Then you're not going to have a security situation. But increasingly, we're finding these things that involve the financialization of NFTs. So it's possible. Now I'm going to take you into an area that's very problematic, could be considered a security, probably will be. What if you minted NFTs in such a way that the original NFT issuer receives a share of proceeds each time their NFT is sold, even long after their initial sale of the NFT? An artist could decide to sell her rights to future proceeds on a secondary market, perhaps even packaging them with rights to proceeds from other NFTs they created, and creating bundles and then fractionalizing these in such a way. Also, NFTs can be used as collateral to borrow other crypto assets. And we're seeing the emergence of that. There's an awful lot of creativity in DeFi. And sometimes, people are really in a situation where they're being very creative, not going to attorneys, not taking cognizance of these kinds of things, and they end up begging for forgiveness rather than asking for permission. Let me tell you, we're well past the period where you want to be in this space and be begging for forgiveness. You're really going to want to be in the space where you're asking for permission. This isn't 5 years ago. This isn't 7 years ago. There's an expectation that that folks out there in crypto world actually should know that there are securities implications concerning certain kinds of things. So, y'all know if somehow your NFT vehicle or your NFT platform was deemed to be a security, then every sale of the token would need to be registered or exempt from registration under the US securities laws. And that can get you in a situation where if you've done that already, you have committed a technical securities fraud violation, in the sense that you offered or sold unregistered securities, or you solicited the offer or sale of unregistered securities. And that can take you into a situation where if you've created a platform dealing in the token, you should have registered under the Securities and Exchange Act of 1934, the 34 Act, and made yourself a securities exchange or an alternative trading system that would be so treated. Or if you're actually engaged as a third party on behalf of folks that are the platform, you could be considered a broker-dealer. And if you're acting as an unregistered broker-dealer, that's also a big no-no. All NFT users on the basis of pretty much have been advised already to avoid marketing NFTs as an investment that can reward holders with appreciation, profit, or dividends. You don't want to actually be the one necessarily making those representations. Not that that couldn't happen because of simple supply and demand, but you don't want to be in the position of being an active marketer where you're trying to get people to buy them based on that, because then you become you're making it seem to the SEC, you're making it seem to the three-letter organizations that you're actually in the business of really hyping the NFT for the purpose of it going up and down in value. This and why is this? Why is this? Because I told you before that if you're selling an NFT that's not a security and it's going up and down in value, is really based upon the supply and demand of the market. What's wrong with a little bit of puffing where you just say, oh, okay, it can possibly reward holders with appreciation, profit, or dividends? You want to be careful in that area. I'm not saying don't do that, but what I'm saying is you really, really should get professional counsel on how to do that. Okay? Because there's a way to do it and a way not to do it. You can literally transform a non-security into a security simply by what you say to your buyers. Okay. If an NFT somehow were to animate a broader investment contract, and I don't have time to get into this. There's a Second Circuit case called the Gary Plastic case, okay? And I want your folks that are doing a little bit of this out there to remember that.
The Gary Plastic case.
Yeah, it's the Gary Plastic Packaging versus Merrill Lynch, Pierce, Fenner, and Smith case. It's actually been around for a while, okay? And it's a Second Circuit Court of Appeals case. And this was a case in which the Second Circuit held that transactions and instruments that themselves were not securities could still be subject to the securities laws if there was if a secondary market was established for something that in and of itself was not a security. So you're telling your buyer, oh, gee, there's a secondary market for this product that you just bought from me. Well, you're just signaling to them that they have a way to sell it. Okay. And if that's a critical part of your marketing efforts, your marketing campaign to sell the NFT, to tell them there's a secondary market out there, instead of just letting other people create that on their own that are not involved in the enterprise, you could have yourself a situation in which the SEC or state securities regulators would look at that and say, we don't care if the actual buy-sell agreement with the purchaser of the NFT is not a security. That transaction is not a security. You've done some advertising that's created a secondary market situation. So this is a very, very, very special area there. And I want to make sure it's all about how you do the marketing of the NFT in the sale of them. Lightning round for this purpose, for just there's a few avoids, if you don't mind. I just want
to. I love. Give us all the landmines. Yeah.
The big no-no, of course, is you want to avoid NFT sales as a fundraising effort to build a platform for future sales.
Yeah, I think we saw a lot of that in 2018 with the whole ICO boom, the DAO boom.
Yeah. And so this is
less of it now.
This is just ICO 2.0.
Yeah.
So you want to avoid that. you want to avoid employing promoters, sponsors, or third parties whose marketing efforts are literally intended to drive the NFT's appreciation. These are what we call the hypers, because basically the SEC is going to look at that as a pump and dump scheme. Okay. And they, the SEC has good reason to be cynical. The capital markets have been going around for a long while. And so the SEC and the 1933 Act, 1934 Act, and the 40 Act, the Investment Company Act, and then the Securities Act of 1933, Securities and Exchange Act of 1933, they were created for a reason. There's a lot.
Sure.
Without those laws, there would be a lot of real bad stuff going on. Okay. Yeah. So the other thing I would like to say is giving NFT buyers the impression that they can reasonably expect capital appreciation of the digital asset or to derive profits from their asset as a result of the creator's effort or the efforts of any third party. That's what I said several minutes ago. You want to avoid. Now, there's ways that these NFTs can be sold perfectly legally without creating this kind of imputation. Mm-hmm. But put through the prism of securities law, these are your watchwords. Now, there's already an SEC probe looking into whether NFTs are being utilized to raise money like traditional securities. There are subpoenas out. The big ticket item is that the SEC is particularly interested in the sale of fractionalized interests in an NFT.
Interesting.
So even if you've created a certificate of authenticity for a piece of work of art, and then you've gone out and you've somehow marketed fractionalized interests in that, or you have a bundle of NFTs and you've sold fractionalized interests in that, that allows multiple people to hold and trade a share of the whole asset. The SEC is really concerned about that right now, and subpoenas have gone out on that. And that's not really, even somebody who's so pro-crypto, like the former SEC chair, Hester Pierce, crypto mom. She said that NFTs, she said this in March of last year, she said NFTs might raise the same kinds of questions that ICOs have raised, unquote. And she went on to say that fractionalized NFTs could be considered unregistered securities. Your audience may be aware of a major player, FTX US. Okay. So FTX, by the way, their former general counsel, who's now their chief regulatory officer, Dan Friedberg, is actually still lives in Seattle. He used to be a partner at Fenwick and West. He's a very, very fine attorney in Seattle, knows his space interestingly. So he had that role last year. So in the run-up to FTX doing its NFT marketplace launch, FTX US made clear it wouldn't list NFTs that pay royalties to their holders on secondary markets for fear that the assets would be considered unregistered securities. Okay, so I can tell you this, that the better practitioners out in this area are aware of this area. Any legal advice you get in this area, I'm not alone here. Any decent legal advice you're going to get is pretty much going to say the same thing I'm saying.
So to bring those thoughts home, and then I've got one question for the audience I'd love to get into, but don't fractionalize your NFTs. Don't start selling fractionalizations of a larger piece.
Mm-hmm.
Don't talk about any expected profit, any expected revenue. In fact, pretend like the secondary market doesn't even exist is probably the best place to be when you talk about your product. And then third, try not to see any interest or realizations on secondary market selling. So,
yeah, well, I would caution that there's a little bit of marketing you can do. I mean, let's face it, people are going to collect these things, like they collect baseball cards.
Sure.
Indeed, there's a lot of collection of these kinds of things, but you don't want to really throw out the entire aura that this is like a securities investment. You just don't want to be doing that. So
great. The last question I'd love to jump to over here is from Anthony Williams, and he says, what would classify as effort by a third party? For instance, would any promotion of the NFT or partnering of the NFT company with other companies in an effort to increase the value of the NFT count as effort? Or would that be considered a reason to expect profit from purchasing the NFT, thus classifying it as a security?
That's a very good question. I think the former, the way it jumps out at me. Okay. There
we go. All right, Anthony. Everyone, also, just as a quick note, I did put a link to the Gary Plastic case in the chat, and so go ahead and open that up or
sure.
save that link and return to it. I know I'm gonna.
That's not a crypto. That's not a crypto case. It's a traditional securities case where a non-security suddenly is transformed into a security situation. And by the way, this doesn't mean you can't do any marketing at all. I mean, my gosh, you just. I think that you should not enter into a marketing campaign with NFTs or have marketing materials on your website or anything else that you do without running them by competent legal counsel. Okay.
Great.
And one final thought, I have in no way given specific legal advice today. I would be pleased to talk with anybody in a professional context who's in this office if they want to contact me. But all my remarks today have been in my professorial capacity and based upon my prior, experience as a regulator and also as a current practitioner, but in no way giving specific legal advice with any particular NFT offering.
Couldn't have possibly talked to a lawyer today without hearing that fine.
Sorry about that.
No, we love it. We love it. We absolutely love it. Well, Joe, thank you so much for the time today. Let them know your website or where they can find you. And
I actually I'm at HTTPS. I'm at Vincent.attorney.
Vincent.attorney. Yeah. So everybody remember, Joe Vincent.
It's actually a high-level domain, so it's Vincent.attorney.
It's Joe Vincent. He's an attorney, Vincent.attorney.
Yeah, and effective April 1st, I will be moving to the Gravis Law Firm that's in about 8 states, including Wyoming, but it has principal offices in Seattle.
Congratulations. Fantastic. Fantastic. Right. Well, Joe, thank you so much for your time today. We all genuinely appreciate it. Thank you for answering our questions, and this is just great advice. And
my pleasure. Thank you so much.
All right, then everybody, next up we have another amazing speaker. He's a legend in the Seattle and national blockchain space. So please go ahead and join our last event of the day. And thank you everyone for coming, and we'll be talking to you all real soon. Okay.